So before the team from the UK holds its mock trial, I will introduce the members of the panel. Playing the role of the judge is, from the Patents Court of the United Kingdom, High Court of Justice, Mr. Justice James Mellor. Playing the attorney for the plaintiff is, from the Powell Gilbert law firm, Attorney at Law Alex Wilson. Playing the attorney for the defendant is, also from the Powell Gilbert law firm, Attorney at Law Zoe Butler. On the tablets handed out at the venue, please look at document number 7, the UK mock trial slides. So please go ahead.
Good afternoon. Before we proceed to hear argument in the UK mock trial, I'm going to spend a few minutes explaining or providing an overview of the procedure adopted in the Patents Court in the UK. So, we actually have 3 different tracks for patent cases in the UK. The track that I hear most of all are the higher value, higher complexity cases, and we generally aim to get those to trial within 12 months. Now, the second track is what's called the shorter trial scheme, and that is a scheme in which you have to complete your trial within 4 days. There are certain other rules, such as limited or no disclosure, and those cases are docketed to a single judge, and they tend to be heard just a little bit quicker. And then the third track is the Intellectual Property Enterprise Court, and in those cases, the trials are either 1 or 2 days, 2 days maximum generally. They get to trial within 6 to 12 months, and there is a damages cap of £500,000. And IPEC, as it's called, is also very suitable for cases of lower complexity. But in each of the 3 tracks, there will be a single judge hearing the case and deciding it. And in general, the patents judges in the UK have both technical and legal backgrounds. So virtually all the patents judges have done some sort of science at university. And finally, there is cost shifting in all of the courts. IPEC has a costs limit of £60,000, so the maximum that you can recover as a successful party in IPEC is £60,000. In the shorter trial scheme, we've recently introduced a cost cap there of £500,000. And in the higher value, higher complexity cases, the costs can often exceed £1 million. Now, we categorize patent cases in the UK by reference to their technical and legal complexity. And so, and there are 5 categories, and generally I spend my time hearing the most technically complex cases, either category 4 or category 5. If it's a category 3 case, then there are 5 other judges in the Chancery Division in the UK who can hear those types of patent cases. And also there's a dedicated judge in IPEC to hear the simpler cases. A category 2 case would typically be in IPEC. The choice of track is initially down to the claimant, but the defendant can apply to have the case transferred to a different track, and the judge also has the power to transfer cases of his own motion, his or her own motion, after hearing argument from the parties. So, moving to the pre-trial procedure. Now, I think the thing to emphasize about all of this is that it's flexible, very flexible, and it's adapted to the needs of the case. But what happens generally is the claimant starts with a statement of case, and the defendant pleads their defense often with a counterclaim for validity or invalidity. And at a very early stage, the parties will seek a trial listing. And that sometimes happens at the case management conference, which is a key interim hearing, and sometimes even before then, because if the party is saying, no, our case is really urgent, we can set quite an early trial date. I think the record for a patent case plus appeal in the UK is 6 weeks from start to finish. So if the parties can demonstrate real urgency, we can accommodate it. Now, in patent cases, we have almost exclusively dispensed with any disclosure of documents because we found over many years disclosure was very expensive but almost completely a waste of time. And in place of disclosure, what happens, the main piece of the main document that a defendant has to prepare is a product or process description. And that is a document which must set out all the facts required to enable the court to decide all the issues on infringement. And in technically complex cases, that PPD, as they're called, can take a long time to prepare, and sometimes there are a number of disputes over them. But those can be determined either by discussion between the parties or in default of agreement by the court. Generally, there's very limited fact evidence. For example, we'd only have witness statements in a case of prior use where certain facts need to be proved. Experiments always come with a government health warning because generally they are expensive and they often fail to prove what the litigant wants to prove. So people are very cautious about doing experiments. But the main evidence in each patent case is the expert evidence. And we rely on that as patent judges to teach us about the technology. The experts will tell us their views on what a particular document discloses, even though that decision is for the judge. And so there are usually a report in chief from each expert and a report in reply. And those reports, the introductory sections of those reports are often used to agree a statement of common general knowledge. And that is an essential document for the trial judge. It introduces him or her to the technology. And also it provides a useful statement of the technical background, which we can just slot into the judgment, so it saves a lot of time. But by the time we get to trial, we will have had opening skeleton arguments from each party, setting out a summary of their positions. And those can be supplemented orally at trial. And what I'll move on now to is a typical 5-day trial. So this would be the procedure for a Category 4 or Category 5 case, one of the more technically complex ones. And in such a case, we might well have 2 experts on each side. We'd hear the evidence. There would be a short break for the parties to prepare their written closing arguments. And then the key point of any trial is the closing submissions. Because at that point, the judge has heard the evidence, he or she understands all the arguments. And at that point, as a trial judge, I'm looking to ensure that I've got everything I need to write my judgment. Now, what I've set out on the slide is the procedure for a one-patent, technically complex trial. But that schedule can be expanded. For example, in the case I did just before coming out here, we had 3 patents with 3 different priority dates, 6 pieces of prior art, and that took, I think, 9 days. But for a simpler case in the shorter trial scheme or IPEC, the whole procedure can be telescoped, And just to give you an idea, if this mock trial was actually taking place in the UK, it would almost certainly be an IPEC, and the trial length would be less than 1 day. Probably get through it in half a day to 3/4 of a day. But still with this structure. Okay, sorry. So the focus of the mock trial, at least one of the focuses, is the obviousness argument. And Section 3 of the Patents Act implements Article 56 of the European Patent Convention, and this is what we call the statutory test. And effectively it is it the invention and the claim? Is it obvious? Now, what I've set out on the slide is a 4-step test from a case called Pozzoli, which generally we use in the UK. And what you'll notice about this is that the first 3 steps are all about orienting the court so that they ask the 4th question, which is the key question, so that we ask the 4th question having properly oriented ourselves. So the stages are, first of all, identify the skilled person and his or her common general knowledge. Those concepts are key for any obviousness case. They're also central to virtually all the issues in a patent trial in the UK. Now, the second step is identify the inventive concept of the claim of the patent. Now, it's not essential to try to summarize the claim down into some sort of inventive concept. In some cases, it's very easy. So if you've got a pharmaceutical patent claiming a single compound like enzalutamide, it's a single compound. The inventive concept is that compound. Now, in mechanical cases where you've got a number of integers in the claim, it can be difficult and it can be a mistake to try and summarize the claim. Because if you summarize it, you risk leaving out some feature that is actually important. So it's not essential to identify the inventive concept. And later on, you'll see in this mock trial, I will decline to try and identify the inventive concept. I will just proceed on the basis of the claim. Now, the third step is identify the differences. That's common to all patent jurisdictions. Differences between the prior art and the inventive concept, or the prior art and the claim. And then you ask the statutory question without hindsight knowledge of the patent and the claim. Would those differences be obvious to the skilled person in the light of their CGK having read the prior art? Now, on this slide, I've set out a typical structure of a patents court judgment in the UK. So this is the structure I'm thinking about when listening to closing argument, because I want to make sure I've got all the elements I'm going to need to address all these questions. So generally, there's an introduction summary of the issues. And the initial findings are the identity of the skilled person or team and their relevant common general knowledge. And as I said, those are key issues for us. So from the viewpoint of the skilled person or team, with their common general knowledge in mind, I then decide what each piece of prior art discloses to the skilled team. Sometimes that's agreed, sometimes it's in issue, and if it's in dispute, then I have to decide what the disclosure is of each piece of prior art. Now, it's a good discipline, we find, to deal with the prior art before going to the patent, because that helps to eliminate hindsight. So next, we would generally introduce the patent, summarize its teaching, and then we move to claim construction or claim scope. Again, that is a key stage in virtually every patent case in the UK, because that is the basis for the assessment of both validity and infringement. And generally, we'd address validity first, novelty, obviousness, insufficiency, added matter, etc., whatever the party challenging the validity of the patent has pleaded. And then we'd proceed to infringement, address on a normal, i.e. purposive construction, and optionally, if the claimant has alleged infringement by equivalence, then we'd address that and then state the overall result. So now we're going to move to the mock trial, and we've heard all the evidence. I've heard the opening submissions, I've read all the papers, and the parties have exchanged written closing submissions, and we come to the sharp end, the oral closing argument. So now the court will sit, and I'll invite the parties to address me. Now, thank you very much, both of you, for your closing skeleton arguments. You can assume that I've read them, but please emphasize any points that you want to. I would like you to concentrate on 3 points in particular. First of all, whether there is a dispute over the common general knowledge, and if so, what it is. Secondly, from the evidence from both experts in cross-examination, I understood that they were agreed that the prior art focused on the specific application of vacuum packing. And I'd like you to indicate whether you accept that or whether you dispute it. And the third point on which I'd like your assistance is the inventive concept of the patent. So, Mr. Wilson, over to you. Thank you.
I'm much obliged. I'd like to start, if I may, with focusing on those issues which have been identified by my lord in terms of focusing on obviousness. I do have an overarching comment in relation to the witnesses, which I think is relevant to the points which I'll make on the CGK and the cross-examination issues. The first point is that the defendant's witness, Professor Tucker, did his absolute best, I'm sure, to try to assist the court. But unfortunately, because of the way that he had been instructed, he was unable to do so. And the reason being that he was instructed in such a way that his evidence was tainted by hindsight. And that is really rather relevant to a number of the points which I'll come to. Conversely, Professor Thoroughbred, who appeared for the claimant, did his best to assist the court, and we would say did a rather good job of it, and his evidence where there's a difference between the parties should be preferred.
Can I just ask you about the hindsight point? Because everybody knows what this food container looks like. I mean, I've even got one at home. So, and no doubt many people in the UK know about this product. So surely I've got to see if the experts manage to exclude the knowledge from their minds, even though everybody is aware of this product.
Of course, there's an issue, or an issue can arise where there's a product which is so popular that the experts would know about it. Our point is really more subtle. It's this: it's that when the expert for the defendant was presented with the patent, they were presented also with the prior art at the same time, and the patent describes the CGK embodiment, that is the use of having of a protrusion, which has been used in the CGK. And to answer your initial question, Lord, the claimant does accept that it was CGK to use a protrusion in this field, but once the defendant had been provided, or defendant's expert had been provided with the patent, which lists in Figure 5 has this very protrusion, and has the claim, the target that the defendant wanted its expert to hit, as well as the prior art, it's almost impossible in those circumstances not to mosaic both the prior art and the CGK described in the patent itself to arrive at the claim. So whilst it's certainly true that, that both parties' experts would have been aware of the product itself, our problem with the way that the defendant's expert was instructed is rather different. It was right before him at the time of drafting his evidence.
Okay, thank you.
I touched briefly on the question of common general knowledge. I didn't detect that once the cross-examination was complete that there was actually much between the parties, if anything between the parties in relation to what was common general knowledge, and particularly my learned friend will come back to this no doubt in relation to the protrusion, which I think is important for her case. Conversely, in relation to the cross-examination of the witnesses, as to the question of whether the prior art or the focus of the prior art and how it would have been understood by the skilled person, both parties accepted, or rather the defendant's witness had to accept in cross-examination that it was directed to vacuum packing for low temperatures and that the skilled person would understand it to be focused on that area. So that was your second question, I believe, my lord. And then finally, the third question you raised was the question of the inventive concept. And we would say that the inventive concept, however it is characterized, should include the protrusion. I mean, after all, the claim is peppered with references to the protrusion. Simply to write it out of the claim in the way that my learned friend would have you do it is inappropriate. And if my lord is put in a position where it's difficult to decide between the two inventive concepts which have been put forward by the parties, and this can arise, of course, in relation to mechanical patents, then the course which we would invite the court to take is to simply construe the claim and not write out this important integer, the protrusion, or integers, in fact, because it appears multiple times. So I believe those are the three questions you raised. If I could progress back to my plan.
Don't let me take you out of your course any longer.
I think the parties are completely agreed in relation to the application of the Pozzoli test, the structured test, but there is a gateway question before one gets to that test, and that is the prior art a piece of prior art that the skilled person would even take forward? And referring back to the question of what the parties' experts considered the prior art to be in the field of, namely vacuum packing and so on, we would submit that the skilled person wouldn't even take it forward. It doesn't address the problem in any way that the patent is trying to address. It's relating to a different field, so that without hindsight, the skilled person would have no interest. And this is a case such as the Asahi and Micropharma case, where the skilled person just doesn't proceed to consider obviousness. But if my lord's not with me on that, and we move to the Pozzoli test, I've already addressed you on the question of what the inventive concept should be, and the inappropriate approach of the defendant trying to delete these protrusions from the claim. The next point I must address is actually the fourth part of the test, of the Pozzoli test, which is whether without knowledge of the invention, and this is important, the skilled person must not have knowledge of the invention when considering whether it is obvious to make those changes. And the changes that would be necessary for the defendant to succeed is that the skilled person would have to throw away the teaching of that reference and start again when it comes to the mechanism, to have a non-automatic manual mechanism and bring in this protrusion instead. I dealt already with the question of how the defendant's problem with its evidence in terms of the hindsight which has been brought in. I should say, finally, that I detect from my learned friend that what she's trying to do, recognizing the problems with the prior art, is actually trying to focus on the common general knowledge which the parties have agreed, namely the protrusion, and is trying to start from that as a starting point. Or perhaps the prior art which is referred to in the patent. Either way, this isn't open to her at this stage in the proceedings. She pleaded her case, and her case is based on a piece of prior art that the skilled person would have put to one side, or if the skilled person had taken it forward, they certainly would have made the changes that are necessary in order to arrive at the invention. This is a case where, with the benefit of hindsight, the invention may seem obvious, but that is not the correct test. The test has to be without hindsight. Thank you.
Thank you very much.
So, my Lord, thank you for your indication of the 3 specific issues you'd like us to address. What I plan to do is I will pick up each of those 3 points in my submissions,
Sure.
Probably in reverse order with your indulgence, but they are certainly things that I want to address you on. So first, my Lord, before I perhaps go on to look at how I say the evidence as it emerged at trial fits with my client's case, I do think it's important to have in mind my submission as to what I say is the core of the invention as taught and claimed in the patent. In other words, in the words of the Pozzoli test, what is the inventive concept? And in essence, I say that the core of the invention lies in the relative positioning of the through hole and flap on the top side of the lid, such that excess fluid discharged via the hole doesn't hit and splash against the flap. I think what we termed during trial as the splash problem. And I think it's really important to have that inventive concept in mind when we come to address each of the differences between the prior art and what's claimed in the patent. So the first difference is heating. I think in the end, I'm not sure really this is a point that's particularly live. I mean, I take my learned friend's point about whether the prior art is a starting point to begin with, and I will come on to address that. But you have my submission that heating in the claim imports no particular limitation, and the reality is that in cross-examination, both experts agreed that in the context of microwave use, the skilled person would understand defrosting to be a subset of heating. So I think perhaps focusing on the protrusion, which is where I think there's perhaps more between myself and my learned friend. So, my Lord, it follows from my submission as to the inventive concept that the precise means by which the through hole is closed by the flap is not material to the core of the invention. And the skilled person would understand that from the teaching of the patent. Indeed, that clearly emerged during cross-examination. My learned friend makes much of the fact that both experts accepted in cross-examination that US 7XX is focused on a different problem to the patent. And my Lord, you asked me about that, and I accept that in cross-examination, my client's expert, Professor Tupper, accepted that the prior art was very much focused on vacuum packing of food for freezing. However, with respect, that misses the point. The skilled person reviewing the prior art would recognize that nonetheless it had broader utility. The skilled person would understand that, it would appreciate that the particular configuration of the flap and hole components had utility for microwave containers more generally. And it was known that microwave containers had a broad use beyond the limited field of freezing. Now, in terms of the hindsight question, my Lord, you've put to my learned friend the point that both experts were well aware of the claimant's product as at the time they looked at the prior art and the patent. And so both were well aware of what was essentially the invention of the patent. And my client's expert took great pains in his written evidence to explain the steps he took to try to avoid hindsight. So finally, in terms of the common general knowledge, which you also asked us to address you on, I was very grateful to hear, perhaps for the first time, that the claimant now accepts that there's really nothing in dispute between us. It wasn't clear in his expert's written evidence whether there was a point taken on whether the use of a protrusion was common general knowledge. But it clearly emerged in cross-examination that he accepted that, and my learned friend seems to concede that point. It was also accepted that the issue of the splash problem, the issue of splashing, was also well known. And I would say that that's relevant when you ask yourself how the skilled person would consider the prior art. So to conclude, my lord, in my submission, the skilled person would read the prior art with interest, would recognise that the relative positioning of the flap and the through hole on the lid solved the so-called splash problem, and that it would be obvious that other closing mechanisms, such as the use of a protrusion, could be used. That's a mere design choice. My lord, if I can help you on anything more, those are my submissions. Thank you.
Mr. Wilson, I needn't trouble you with any reply. What I'm going to do, I will hand down a full written judgment in due course, but the parties have specifically requested a summary of my conclusions at the conclusion of arguments, so I will briefly identify and explain the key points. The skilled person and his or her CGK, well, the skilled person is obviously a mechanical engineer with experience in product design and production techniques of an array of known food containers. The key point about the disclosure of the prior art is that the hole and its flap operate automatically, being opened and closed by differential pressure. Moving to the patent and its teaching and the key issues of claim construction, I'm going to apply the normal principles, and my task is to make a purposive construction of the elements of the claim. And so the overall test is, what would the skilled person understand the patentee to mean? And in response to a particular point raised by the plaintiff in his skeleton argument, it's quite clear on the authorities that the specification and the claims must be read together, because the purpose is usually to be found in the specification, and it's not only consulted to resolve ambiguity. And I'll also refer to Nokia and IPCOM. It is illegitimate to write additional limitations into the claim. So the parties identified 3 questions for me to construe, and I've stated those conclusions on this slide. Specifically, a through hole is to allow the passage of gas or fluid, air, steam or water, and it's not limited by the preferred dimensions in the specification, provided it fulfills its purpose. Moving on to validity, I've identified the 4 steps of the Pizzoli test, and I find that it would have been obvious to apply the prior art arrangement for heating food, but it would not have been obvious to alter the prior art arrangement of flap and hole. It would be clearly counterintuitive for the skilled person to throw away the automatic operation of the flap and hole in favor of a CGK arrangement of hole and stopper. So I hold the patent valid. In terms of infringement, there is no equivalence argument. I did not find the experiments at all useful, but on my construction of a through hole, the defendant's product has such a feature, and therefore there is infringement on a normal construction. I find the patent valid and infringed, and I will appoint a short hearing in due course to hear argument about injunctive and other relief. Thank you very much.